Due diligence. Obviously, like the investor will do a due diligence, okay, on the company. They will start looking at the documents. They will start looking at lots of different things. And here is where, if you are together with the founder at this time, when the due diligence start, because inevitably due diligence results in certain things being found out which the founder would not have expected. Okay, because it's a very in-depth checking, there will be certain things which are found out. So now if you are there with a founder or a businessman at this point of time to help in certain things, okay, they will be sold onto you. Literally, they will be sold. And what are those things? Ongoing litigation. Okay, so you have to, if there is an ongoing litigation that is there for the startup, and you are aware of that, of the status, you are seeing what is happening. Okay, so you can get the kind of details, you can check of what is likely to happen. All of that you can look at, and you can provide and advise the founders on what route to take. If there's ongoing litigation, there may be already existing lawyers involved who are doing this as well. But okay, you will just look at it on what's going on how to advise the founders and how to provide the details of that to the investors. Maybe you, if you have an idea that comes up now that you have been with the business, you may be able to look at taking later litigations for the company as well. You may be able to suggest a better route or a better strategy that the existing lawyer takes on this litigation. Related party transactions, inevitably you will find in startups. This has to be there, because in the basic stages, where will the money come from? The founders will have put money. Who is doing the work in that? It's the founder and the family and friends who are going to be doing the work. So they will be getting some payments in the initial stages, right? The first people you approach to is your family, that, okay, can I, do you know someone else who's like that? Okay, will you help me sell my product there? Will you help me do this? And you may be making payments to them for doing that. Your cousins, whatever it is. Okay, so there will be related party transactions. Okay, usually these will be there. And most founders don't know that these are related party transactions. So if you are aware that this is how it is, okay, and it's a whole different chapter of discussion itself. If you are aware that it is a related party transaction, what is the kind of compliance that you need to bring to it? What will make it completely come out of any kind of regulations? Okay, all of these things, if you are aware of, then you can advise the founders on related party transactions. For example, I'll tell you one particular clause. Okay. AS 18 is an accounting standard. We are not talking about accounting standards here. We are talking about the requirements under the Companies Act for related party transactions. Okay, so there is a specific compliance that's required that you have to enter into for related party transactions. But one section or one proviso in the act says that if you are entering into these transactions at an arm's length basis, okay, and for normal business purposes, then nothing in that section applies to it. So just think of that. You may be able to advise a way, or you may be able to find a way so that nothing becomes applicable. But how do you do that, and how do you document that? This is where the lawyer will come in. Okay, when you do these kinds of things to advise the founders, they will be really happy with you, because you are setting everything as a system in order for them, and you are also making the company really ready so that the investor is not going to be able to find any loopholes. They can see that, okay, this is correct, it's complied with. Okay. Borrowing or deposits, this is another stunner that you can find. Okay, because like I said, where do the initial money come from in the company? Everyone will not be given the shares. So someone would have given an unsecured loan to the company. Okay, and that's what falls in the range of deposits under the Companies Act. Somewhere they will have borrowed some money from the bank. Okay, and whether that money works with the provisions of the Companies Act or not, you don't know. Okay, So all of those things, if you check and if you streamline it for them, that's when like they will be very happy. Intercompany transactions. Now, if there are 2 or 3 companies in the group, or maybe even partnerships and companies or things like that, okay, if there are entities like that, multiple entities, and there are transactions between those, these are also regulated, and you can advise the founders on this. And these are all the things the investors will check and take out. They'll dig out. Okay, it's like an audit. So they'll dig out all of these things. Now, if you're standing with the founder at that point of time and saying that don't worry about it, I'll do this, I'll get these things in order for you. Okay, when you do that, that's when you can rely that they will always give you any of the later work after that. Labor law compliance, employment or consultancy agreements is another thing. Okay, they might not know properly how to draw employment agreements or consultancy agreements. They might not even have consultancy agreements with anybody. Okay, so they are hiring a consultant, they are giving invoice and they are making payments, and that's how it's happening, but there's nothing like a consultancy agreement in place. You will find this often. Okay, so you can arrange these things or put these things in order. Okay. Why is it relevant for the investor? Because if you don't have all of this, and someday later someone comes up with some terms and states that this is how it was, and I initiates litigation, investor doesn't want to take that chance. He'll say, get your house, get everything in order, and then I'll come and invest.